Welcome to Accelerate, a DLA Piper hosted series focused on AI. During the series, we will help demystify the complexities of AI regulation, risk, and how to harness the opportunity that AI brings to businesses across the globe.
I'm Giulio Coraggio, location head of the Italian Intellectual Property and Technology Department at DLA Piper in Milan. Generative artificial intelligence has massive potentials. However, it's under the radar of European data protection authorities. Authorities have challenged the three stages of generative artificial intelligence: the data scraping, so the collection of data, storage, and the generation of outputs. This scenario puts companies in a tricky situation. They want to exploit generative AI, but they don't want to face the risk of potential challenges. Now, at this stage, a potential solution is given by some European data protection authorities that didn't consider the storage of information processed by generative AI solutions as a processing of personal data. This means that if the data storage is not a data processing activity, it's not within the scope of the GDPR. Some argue that these are pseudonymized data. However, if a detailed analysis of the process is performed, we believe that there is room to argue that this is outside the scope of privacy laws. We will still have a data processing activity in the data scraping, in the data collection of information then processed by the generative AI. However, the implementation of legal design solutions and of technical data minimization options would support the position that there is a legitimate interest underlying this data processing activity that therefore can be considered to be compliant with the GDPR. In order to maintain this position, we would recommend companies to follow 4 stages. First of all, implement technical solutions to make sure that the data minimization principle is observed, limiting the data processing of personal data to what's strictly necessary for the purposes that need to be achieved. Secondly, we recommend to run a very detailed data protection impact assessment in order to argument why the solutions implemented limited the data processing just to the data collection phase, while there is no data processing in the storage of data, and while in the generation of outputs, there is no actually processing of the original data, since the generative AI solution is creating the outputs. It's not just copying information previously obtained. The fourth stage is to draft an information notice, a privacy information notice that is very detailed, is very transparent. As I said before, implementing legal design solutions that would make clear to individuals how their personal data is processed, creating a legitimate expectation in relation to this data processing. This interpretation, this solution would be a valuable defense for privacy-related challenges, but could limit the risk of challenges also under intellectual property laws, because there wouldn't be any copy of the original documents. These documents would be processed at the initial stage, but then not stored and not part of the outputs implemented. Obviously, from an IP law perspective, some guardrails need to be implemented, but it seems that this solution is a win-win option that, if properly implemented, can be an adequate protection for any business that wants to exploit generative AI.
Thank you for listening to this episode of Accelerate by DLA Piper. For more on AI, Check out our YouTube channel for more videos like this and click subscribe to stay informed. You can also take a look at our AI focus page on glapiper.com for further insight and thought leadership, and get in touch direct to discuss how we can support you in navigating the complexities of AI.